Thank you, Mary. I'd like to call this Board of Selectmen to order by Selectman Straighten and Selectman Turgeon. Please rise and join us in the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first thing on the agenda, we need to appoint an acting first selectman.
I make a motion.
Okay.
I make a motion that we appoint Rich Straight and acting for a selectman of the town of Buffalo.
Second. Any other discussion? There's only two of us now.
Two of us.
All in favor?
Aye.
Aye. Thank you. Thank you, Brian, for your confidence. Next, we have on the consideration or approval of DOH to accept the DPH contract amendment 2020-0042 amendment number 2020-0042-2 in the amount of $5,142 for Johnson School United Sports Program dated October 1st, 2022 through September 30th, 2023. And we have Laura Basile here from the Health Department to explain this for us.
So the Johnson School grant provides for the coach, health teacher, Nat Claridge, and the special ed teacher, Jessica Bouchard, to offer unified sports program, which is physical activity and lifestyle, nutrition, support, and decision-making for special ed students and their peers that participate with them. And they'll do this for this school year. Last year, we were recognized for what the instructors did with these youth and in the community, and that $5,142 pays for those two teachers, and I do all the reporting and documents in my capacity. And I'm hoping that for the fourth year that you'll accept me doing.
I got ahead of the schedule a little bit, but I'll make a motion that we approve the application for the grant from the DPH for the Unified Sports Program.
Second.
Any other discussion? All in favor?
Aye.
Aye. I skipped over a consideration of the dates for the special election. Brian, there's a memo in here.
We're talking about caucuses between October 18th and 25th.
Correct.
If there's a primary, that'll occur on December 13th. The special election date will be February 7th.
Right.
And the parties have to publish a legal notice 5 full days before the caucus.
Correct. You want to put that in a motion?
I make a motion that we accept these dates as stated.
Second. All right, and it was through the registrar's office that help get us these days with the cooperation of the town clerk. And Tim, you have anything else?
Yep.
Okay, all in favor?
Aye.
Aye. Okay. Next on the agenda is an appointment of special town council for docket FIC 2022-0206 Bradley Colts versus the chair of the Board of Finance, Town of Bethel, Board of Finance, Town of Bethel, and the Town of Bethel. I'll make a motion that we appoint the special counsel, and we have a second, so we can discuss it.
Second to discuss.
Marty, you want to fill us in?
Yeah, you'll notice there's three appointments for special town council. At the time that all three of these complaints were filed against the town, they were having, all the hearings were being done via Zoom. And what's happened is effective September 5th, it came out of the blue, all the hearings now have to be in person in Hartford. I am not able to do that. So what's happened is this first one that we have here, there's a couple of them here. Hold on a second here. This first one, I filed an appearance for the town and I requested that it be scheduled for electronic. I was advised that they wouldn't do that. I never received anything in writing. I was just told that over the phone when I called a couple times. And then there was a hearing originally scheduled for October 4th. I had asked that that be continued too, because the point I needed to get other counsel. And I was informed again orally over the phone that that was granted, but I'm still waiting for a date in which to have a hearing date. So in the meantime, I spoke to a representative at Martha Cullinan regarding the possibility of representing the town at these hearings. Their main office is in Hartford. They're right there. They're very familiar. I spoke to attorney Nick Vitti, but there are other members of his firm that are very much involved with FOI matters. They do a lot of municipal law. So that's what my recommendation would be for this one and the other two as well, which I'll explain when they come up. But I will say this, I was informed by attorney Vitti that they have an outstanding matter that they're representing somebody for in front of planning and zoning right now. But the way I looked at it is it's FOI and going in front for land use approval is apples and oranges. So I don't have a problem with it. He advised me that they could always submit a conflict of interest form, which we have accepted in the past, where we thought there wasn't going to be a problem. And I don't foresee this as a problem at all. So if possible, I would like to have Martha and Cullinan appointed as counsel, and I can get the documents up to them right away. They can file an appearance in lieu of me and start the process.
Can we add that to the motion?
Yes.
Is that right? All right, any other?
You're saying that, are they a plaintiff against the town in the other case?
No. What they have an actual land use matter that one of their attorneys are representing at the Planning and Zoning Commission right now.
Okay, so it's non-adversarial, they're just representing.
No, it's not that I know. No.
Application before them.
And they're going to submit paperwork regarding the conflict interest, and which we've accepted in the past in a couple matters, and we've moved on. I remember specifically Cohen and Wolf. What happened was there was a statewide matter that was taking place that affected our area here, and Cohen and Wolf, I think it was Monty Frank, I'm just guessing, I can't remember the name of the attorney. He was representing several towns in the area regarding the state issue. And what happened was Bethel wanted to join it. They did join it, but there were matters pending, as you know. Attorney Marcus represents many people in front of our zoning boards. And he was already representing somebody from the same firm. So in that case, we said, again, it's apples and oranges. We just signed off on the conflict, and that was it.
All right, all those in favor of hiring the special attorney?
Aye.
Want to say aye? All right. Second appointment of special counsel is for docket FIC 2022-0206 Bradley Colts versus the Chair of Finance, the Town of Bethel, the Board of Finance, and the Town of Bethel, and of the Town of Bethel and the Town of Bethel. It's the same thing, Marty?
No, you read the same, you read the wrong. The next one is the same thing. It's Colts,
Oh,
but
I'm
it's
sorry.
planning and zoning.
Thank you.
It's
All right.
Colts, it's planning and zoning.
All right, let me redo that one. Make a motion that we appoint the special counsel for docket number FIC 2022-0216 Bradley Colts versus Chair of Planning, Director of Planning and Zoning Commission, the Town of Bethel, Planning and Zoning Commission, and the Town of Bethel and the Town of Bethel.
Marty, are these FOI things?
Yeah.
So this has to do with information
requested that the town feels it doesn't need to release, or is it something else?
Yes, that's basically what it is. It's a FOI request. There's a long list of exemptions. Some of the things we never have an issue with. There's some things that do. In this case, we just completed a hearing on the same thing on this case regarding planning and zoning. And that was done by Zoom several months ago. We haven't had a decision by the hearing officer. In fact, today I had to submit a brief, and I did submit a brief to the hearing officer, and it's along the same lines here. But again, it's something that they already came up with a date, believe it or not. They had a date scheduled for October 17th for a hearing on this matter. I had never, I never put an appearance in for this matter because I was not aware of it. I was never informed by anybody who were named in this that we received the actual complaint until about 2 weeks ago. And at the same time I found out about it, a notice came out for a hearing for October 17th. And there's, like I said, I can't go to Hartford. I sent a letter, I should say an email request stating that I didn't file an appearance, that I was town council, that I was requesting an extension, that I couldn't go to Hartford, and that we needed to have town council appointed, a special town council through the Board of Selectmen. I was basically told in a nice way, since you don't have an appearance, it has to come from one of the actual respondents. So I believe Beth Cavagna, on behalf of the Planning Commission and the town, requested a continuance. It was granted, but it was granted with no date. They just said that that it could be rescheduled next 8 weeks and to notify them of availability, et cetera. And that just came out last week. And I'm asking that it be the same firm be appointed, Murtha and Cullinan.
Any other questions? All in favor?
Aye.
Aye. All right, we have one more appointment, special town council, so then we'll go back to the turf field. Appointment of special town council for docket FIC 2021-0357, Patricia Pope versus Chief Police Department, the Town of Bethel Police Department, and the Town of Bethel.
All right. This one's a little bit different. This goes back a ways. There was supposed to be a hearing held via Zoom again. I put an appearance in for the town and the police department, and there was supposed to be a hearing held on in April. And what happened was I had 3 witnesses. One was obviously the chief. Another one was the actual officer that was involved directly with Ms. Polk. And the third one was a lieutenant that actually handled the FOI request. Very difficult to get all 3 of them on the same page for the same day for the hours. So to make a long story short, we ended up getting a continuance. They rescheduled the meeting and we had to get another continuance for that. All right. They have never informed me when the new hearing date is going to be. So this has gone on for the entire summer. And I assume that it's no longer, originally was scheduled to be a video conference. I assume that based on the entire commission's ruling, FOI commission's ruling in the beginning of September, that it will no longer be. That when it is convened, it's going to end up being in person in Hartford. So I'm recommending that it be the same firm, even though this one is much farther along. I actually had, draft questions written out. I was ready to proceed with the hearing, but we just couldn't get together. So, and the other side is represented by counsel. So I'm asking that it be the same firm be appointed, Murtha and Cullinan.
You second that motion?
I think so, but I'll second it now.
Okay. Any other discussion? All in favor? Aye. All right, let's go back to this discussion, consideration of the acceptance of the VHS turf field. We have Attorney Olson here to explain things to us.
Good afternoon. I'm Peter Olson, I'm acting as special counsel to the town. The Turf Field project. Call that the town entered into a ground lease with Bethel Turf Group, Inc. for the purpose of building the turf field, portion of the school property. The project has been completed and a certificate of occupancy has been issued. There's really one outstanding, well, I guess there's some minor punch list items that have to be completed that they're waiting for parts to come in on, but nothing significant. The major issue that remains is that technically, anybody who provides work to a project is entitled to be paid for that work, and if they're not paid, they have the right to put a mechanics lien on the property for 90 days after the work is complete. So theoretically, we don't know for sure that everybody's been paid. And in fact, we know that they haven't been paid yet because Claris hasn't received all the bills yet. It'll take them some time to process those bills and they will get paid. So we had a similar situation with the track and field center. And what we did was accept an affidavit from Claris that set forth the invoices that had been sent out that were outstanding and said that they were holding funds sufficient to pay those invoices. We got indemnity agreements in case anybody put a mechanics lien on, that they would take care of it. That all is still to come. We're still working on those documents. What you have before you is an acceptance agreement for when we receive those to be executed at that point. So we're not asking you to approve the acceptance agreement for execution right now. I'm asking you to approve the acceptance agreement as to its form. When the documents are received, then we'll be able to sign this and accept the turf award. The reason we're doing this is because everybody wants to have events on this field as soon as possible. In fact, they're having an event today, being able to be a temporary agreement. So the point here is that once those documents are received, we don't want to have to schedule another meeting of the Board of Selectmen when we know what this document is going to say. That's the purpose of this. Now, what this does say is that they've terminated the ground lease. They've provided us with documentation I've asked for regarding the mechanics lien issue. That they agree that if anything remains unpaid, they will take care of it. That's an agreement for them to do that. That they assign any warranties of workmanship or product under their agreement with Claris to the town, so that if there's an issue with any of that, the town goes directly with Claris to resolve any of those issues. We step into their privy of contract. And we provide an indemnity against to the tenant against any claims that may arise from product or use of the field. The last paragraph, there's no employment relationship, was asked to be added to this by Colonel. And so that's basically it. So what I would like you to do is make a motion to approve the form of the acceptance agreement to authorize its execution upon receipt of the documents by a special town council.
So move as Attorney Olson had mentioned.
I'll second for discussion. Attorney Olson, what happens if they don't? The outside chance that Claris doesn't pay the bill, what is the town's liability?
So we're going to collect a whole bunch of documents from them. And one of them is an owner's affidavit and indemnity agreement. That's the tenant is the owner in that case. And one of them is the general contractor affidavit and indemnity agreement. Under both of those agreements, they agree that if a mechanics lien is put on the property, that they will immediately take steps to remove it and to bond it over so that there's no lien on the property and any fight can be had over the bond. Second, we have this agreement in the acceptance agreement that they would do that as well. So both of those should result in the mechanics liens being eliminated as soon as possible. Should result.
Do you know the amount that's owed currently?
I don't know. That's one of the things we're waiting for on the documents. I'm expecting it to be between $100,000 and $200,000. There's an additional issue I really don't know how it's going to be spelled out in the affidavits regarding whether or not they have to pay prevailing wage to the contractors. With the track and field center, the Department of Labor granted a prevailing wage waiver. With this project, they did not. We don't know why. I don't know why. Their lawyer doesn't know why, but they've taken an appeal of that. And there is supposed to be funds set aside to handle the loss of that appeal. But that's part of what I'm waiting for in documentation, is to make sure that we're comfortable with how that's going to be handled.
Now, the agreement you have in place so kids could use the field, how long has that been for?
It runs out today. It's a 2-day agreement, not even 2 days, it was yesterday afternoon and today. There's apparently a desire to use the field on Thursday, and I would doubt we have the documents by Thursday. We may have to do a separate agreement to cover that. I don't really want us to be in a position where we keep getting temporary agreements. I want this resolved permanently as soon as possible, but I'm really at Claris's mercy until when they get this done. And just to be clear, the law is you have 90 days from when you finish work to put a mechanics lien on the property. And the ground lease says you can't turn this over until those 90 days have passed unless you give us all these documents.
When was the CO completed? I know that-
Friday,
So the CO was just Friday.
Friday,
So they have 90 days from Friday.
theoretically, yes.
So that'll take us into almost January.
Right, but the point is that if Claris has the money from Turf Group Inc., then all we're talking about is making sure all the invoices come in and making sure the funds go out. And that's, should happen because Claris is a good company that we've relied on.
And it's a similar application that we use on the field house.
We did exactly the same thing on Fieldhouse, which was a 5 times larger project.
I mean, if someone put a lien on the town anyway, I mean, what are they gonna get from that selling the turf?
Well, I don't think,
I'm just curious.
They can take it over.
You know, if they wanna take
They
it.
roll it up and take it out.
They're gonna take. up
here's the problem, is the turf
Yeah.
field property is just a leased area of the school property, which has all of our schools. And honestly, it is not good for anybody if there's a lien put on that, let alone if somebody then tries to foreclose that lien. Nobody wants to be in that position. So this is the trade-off that we're trying to reach, is document everything that's due so that we're comfortable with it. Make sure everybody understands how it's going to be paid and when it's going to be paid. Then we'll be willing to accept the turnover early.
But nothing gets signed until your law firm says that you're 100% satisfied.
And going back to the prevailing wage, the money is set aside for that.
They say the money is set aside for that. That's one of the things I'm looking for, is documentation that it is set aside. Where is it? And who does it get paid to if the appeal is lost? I just don't know the answer to this. Does Claris have to pay a penalty for not using prevailing wage? Is the contractor entitled to additional payments? Presumably the contractors have contracts that say, we'll be paid X dollars, and they just get an extra 10%. If they don't get that 10%, can they put a lien on the property as a mechanics lien? These are all things that have to be spelled out. And that's, I think, why it's taking a while.
If it's a prevailing wage job, though, Claris has to document, there's a lot of steps in those prevailing wages where you have to document everything. So I find it hard to believe that they just started this on the limits, without knowing that, because there's a lot of documentation there.
I find it hard to believe they went ahead with it as well, but they wanted to get the project going and finished.
And what do you think the cost difference is if it ends up being prevailing wage?
I don't know the answer.
20-30% level?
Probably a
Minimum.
reasonable guess.
And is the,
But like I said, the subcontractors entered into contracts with Claris at a certain fixed price. So I don't know if they're entitled to more money if
it's
it
a
was supposed to
prevailing-
have been prevailing
If it's a
wage.
prevailing wage job, sure. they can-
But what if the company that did it doesn't have union employees or the capacity to do prevailing wage?
I know I don't have employees, and I was asked to do a job that was prevailing, and I didn't want to deal with the paperwork.
Yeah, so
yeah.
So
Way
there's
over
a
my
lot
head.
of outstanding
I said
questions
thanks.
as to what happens if this appeal.
Yeah.
let me ask the turf group. Are aware of this.
They are aware of this.
Okay.
Number one, we put it in the ground lease.
Okay,
And so it's been that way since the beginning. Number two, I was very clear with everybody up front that this was going to be an issue because they were going to want to turn over the turf field immediately on completion. And lo and behold, here we are. I mean, at the end of the day, nobody wants to hold up kids being able to use the field, right? That's the fundamental issue.
When do you think realistically you'll have the documentation? Realistic. Not an attorney.
End of the week.
End
of the week.
Okay, so Friday.
But there's a difference between them getting me the documentation and me being satisfied that the documentation is complete.
And how many games are they able to use the turf field under the new agreement? Because don't they have to stand games?
It was for today, the whole day.
Yesterday afternoon and today.
But then Thursday you need a new one.
Yeah, I may have to do a new one for a week to cover. I just don't want to have to keep doing that.
And just that, an answer to this question, just because we have a lot of balls kind of floating up in the air. I mean, we do have a responsibility at the town of Bethel to protect them. Would it make sense to structure this agreement till next Tuesday and the business day, because we're gonna have another meeting? And then you could come back to us and say, hey, look, I'm satisfied, we're good to go here, and we don't have any, you know.
It could be, we could wait till Tuesday. If they got me the documentation tomorrow, though,
Oh, you'd rather sign it.
I'd like to be in a position where we know it's authorized to be signed.
I understand.
And I can report back to you that we received all the documentation and the documents have been signed and the ground is determined.
I mean, I'm sure you have Arizona mission insurance. You're not worried
Yeah,
about this, right? You're not worried about this at all. I mean, I know Mr. Olson's a good attorney, so, I mean, if you feel very confident that this is safe to do, I mean, you
I
know.
do, and we have the immediate prior history of the field house, that this worked for the field house. Again, it has to be documented, but
Yeah, I'm okay.
All in favor?
Aye.
Aye.
okay, good.
Thank you.
If you want me to, I'll report back next Tuesday.
Yeah, or
Shoot us an
if you-
email if it's earlier.
Yeah,
You could always
yeah.
shoot us an email and just let us.
Well,
know.
I'm gonna need somebody to sign the document.
Yeah.
You wanted to be acting first.
Yeah, exactly. There's acting for selectman right there.
Exactly.
All right, thank you. All right, next on the agenda is
Executive session.
executive session, 134 South Street. So I would ask Attorney Lawler to be in. Mary Churchill from the Selectmen's office, and ask Brian and myself, and goodbye to everybody else. Thank you. Would you please shut the door, Brian? Really. Okay, it's 4:10. We're coming out of the executive session. We've had discussion about the lot 134 South Street. We're going to authorize Attorney Martin Lawler to continue negotiations on the purchase of the lot and get back to us by next selectmen's meeting, October 18th, I think it is.
Yes.
I'll make that a form of motion.
Okay.
All in favor? Aye. Motion to adjourn?
Second.
All in favor? Aye.
All right.
Thank you.
No problem.